Okay, all right, here we are. So guys, it is Friday, March 19th, and I want to welcome each and every one of you to our education session. I'm going to remind you a couple of things. Firstly, if you can all please mute your microphones, just because it's very distracting if one or two people do not, and they don't realize that they're actually on session. Second, normal caveats apply to this session. While our Facebook group is private, these video sessions are public and published in a multitude of public forum. So be advised that any questions you ask will be recorded and will be going out accordingly. Last and final administrative note, I just want to thank everyone. We are now at 6,500 people, and we're going up quickly. The caliber of our group increases every time we have more of you join and contribute, and very, very grateful for everyone's efforts and everyone's continual efforts to make our group a better place. I think we're all getting a lot out of it, so thank you very much. So without further ado, because my voice is, I'm sure, melodic for you guys, but Brian Madigan's voice is far, far better than that. First of all, guys, I'm going to ask for everyone please to mute, if you don't mind. Guys, I'm going to have to mute you myself as well once Brian takes over, but please, if you can mute. So without further ado, this is Brian's second session that he is spending with us. What I would mention about Brian in particular is that Brian is probably our senior educator in... sorry, 1 second. Brian is... Sorry, guys, we're still having reverb. Can I ask? I'm going to take a second, and I'm just going to make sure that everyone is muted. Sorry, hold on. Okay. Because there is still someone who's talking in the background. Sorry, I know that there's a way to actually have people come in on mute, but all right. Hold on. There we go. No, yes, perhaps. I think we're good. Okay, good. Let's race two. So Brian is one of the premier educators in our circle. And by our circle, I mean really realtors generally. Brian has been teaching this stuff for longer than I've been practicing. His knowledge of these areas are deep and profound. And really, we all rely on him as really an expert in the areas that govern our daily activities. This is really a privilege for us to have him here because Brian provides full day courses on these exact type of subjects. And so you guys can think of this really as a taste of Brian because he's actually in the middle of offering one of his session-based courses, which I'm going to let him speak to as well. Maybe at the end, Brian, you can mention what your courses are and how people can sign up. Really, it's a treat, guys. And if you haven't attended his courses, they're almost must-haves. I was a professor or a lecturer down at the OREA college. Trust me, Brian's courses are more complete and better. These are things you guys really should partake in when you get the chance. It is well worth your professional while. So without further ado, Brian, I'm turning this over to you. I'm going to just make you... let me see. I'm going to make you the host here, okay?
Okay.
All right. Oh, sorry, Brian, 1 second. I did not. Hold on. I need you to just put me back to host for 1 second before you do. I apologize. I didn't push record. I'm sorry.
Okay. I don't know.
You go to my window and you push on the 3 dots and you just say make host. Sorry about this, guys.
I'm showing that it is recording.
Yeah, it's recording, Mark.
Oh, okay, perfect.
Okay.
Sorry. Okay, go for it.
I did.
All over to you, Brian.
Okay. If there's one thing that people need to know is tech stuff is not my forte. And everybody who is tech support, namely my 5 kids, have all moved out of the house. So it's very, very challenging, sometimes even to answer a cell phone. Having said that, I did do a lot of litigation in the 1970s involving real estate matters, several hundred of them actually. And so that's really the basis of a lot of my interest in real estate as an area in terms of litigation. The next step up for me was actually to do personal injury litigation and medical malpractice. So it was medical malpractice, which is actually my specialty, not real estate. So in any event, we're back in the real estate business. So what I'm going to do is I'll be sharing my screen. As soon as I do that, I won't be in a position where I can see any of the people. So we can't really have questions until the end. So I'll go through the presentation. There are a couple of courses which I would mention that I do have if people have some interest in that at the end. So if you don't, then you can exit and leave and get back to business. And hopefully everyone will be able to make a sale today, or at least get an offer submitted on something and be one of the top 50 offers. In any event, let me go through this. So it's a good thing that I went back yesterday and read exactly what Mark had mentioned in respect to today's presentation, because I would have probably brought a completely different presentation today. In any event, this is brand new, hot off the press, and I think that it'll work. Now, this is really designed for people who are new in the business. So this is real estate 101. It's not real estate class 202. That's something we can do in another session. So what I wanted to do is go through a couple of classes that are important, that come up all the time, and deal with them and what they happen to mean. And it may not necessarily entirely be always what you necessarily think. So let's start out with the basic deal. We're starting out with an ARIA form, standard form agreement of purchase and sale. And it's important to be aware that caveat emptor prevails. There's no implied warranty of fitness for habitation. Every purchase is on an as-is basis. That's the condition of the premises, unless something is said to the contrary. So if you don't put something in, you're stuck. That's what it is. Now, the interesting thing that you'll oftentimes see is a power of sale. And a power of sale provision will say, oh, we're selling this property as is. That's not new. That's not different. That's what the law is for hundreds of years. That's the deal. And they're just emphasizing it. This isn't something that they're introducing as being new. So the result of that is that after a period of time, some people read that and think, oh, well, a power of sale is as is, but they don't re-emphasize the fact that every transaction is as is. And that's set out and re-emphasized in case Fraser Reed and Drumsikis, Supreme Court of Canada in 1979. So that isn't even really all that new now. Now, what do you want to do if you were to protect the buyer? You're on the buy side. You've got three options. This is set out by the Supreme Court of Canada in that case. And this is going to come up every time there's any kind of litigation involving real estate. So first of all, you have the opportunity for an express warranty. Put it in writing is what they're saying. Number two, you have the opportunity for an independent examination of the premises. So if you modify that in a residential transaction, that's the home inspection. For commercial, of course, that's going to involve a number of other matters, including an environmental assessment and review. But when we're talking residential, which is the emphasis today, real estate 101, of course, that's where we would go. And of course, the other thing is do both. Put it in writing and also have that opportunity to inspect. So the mere fact that you have an inspection doesn't mean that you can't put any warranties in. However, the Supreme Court of Canada, when they're talking about this, is talking not about any particular market or the market that exists in Ontario in March of 2021. Boy, these warranties are not going to work. Conditions with respect to inspection are not going to fly, nor are financing conditions. So that's going to be problematic. Nevertheless, that doesn't detract from the fact that you've got to be aware of what are the basic rules with respect to all of this. So it's important to be aware that an agreement of purchase and sale is an executory contract. It's a contract where the deal is there's going to be a deal, and the deal is going to go for some considerable period of time before it's closed. Then when it's closed, it's over. We're finished, kaput. There's no going back. So it's not like going in and buying a coffee at Starbucks or Tim Hortons and you give them the money and they give you the coffee and we're done. There isn't anything more to it. That's finished. This is something which is an executory contract. So they're looking at, okay, there's going to be a time period. And then historically, what the courts have done is said, you know what, when it's over, it's over. Whatever deal it is that you did at the end on closing, that's your final deal. So if you put it in writing and you stretched it out on the closing of the transaction, that was fine. For those of you who are travelers and get the opportunity to travel around in London, England, and can look at old deeds. Old deeds were 50, 60, 70 pages in length, all handwritten. And they included a lot of different provisions in terms of warranties and what was going to happen and so on. And so they would prevail. But so when they came back and said, once you've got a deed, you're done with this. You fooled around with the property and had the deal on paper for probably a year, year and a half. But now once you've taken your deed, that's what we're going to look at. And of course, what we know today, of course, is there's nothing in the deed that's going to give you any additional special rights. So you had to negotiate that up front and make sure that the doctrine of merger doesn't apply. So what it would be is once completion is come and gone, is just like this contract was ripped up and thrown away, put in the garbage, we're done, just like it never existed. And we're going to look to what is the paperwork that the lawyers had on completion. That's what's going to survive. That's what we're going to have. And of course, if you don't have an opportunity to put something in the closing documents,
he talks about
that
the
can actually
legalities of
arise
survive and not merge.
if in fact someone has put that in the agreement in the first place. So the real estate agent has to put that in the agreement. If they don't, then the lawyer doesn't have the opportunity to freshly intervene and reflect an agreement that didn't exist. So what you've got to do is get it in. So how do you save it if you've got something? Well, you want to make sure that you have a continuing warranty and representation. You must express that specific intention that it will survive afterwards as an independent collateral agreement. Now, you can do one of two things. You can be like Fraser Reed case, and you've got to take it to the Supreme Court of Canada. And the Supreme Court of Canada says, you know what? We actually honestly believe that you had the intention that this was an independent collateral agreement. But my gosh, who has the money to go to the Supreme Court of Canada? So why don't we just put it in writing up front? In that regard, what we want to say is it won't merge. That means it's still there. And we also want to say it will survive closing. And so if we do that, that's absolute proof of your intention. We don't have to inquire any further. Courts will say, well, that was pretty clear. You just go to it and do they want that to survive afterwards? Obviously they did. That was in with the parties. Otherwise, the court is going to look and say, it was bad condition. The building was in bad condition, but the people closed anyways. Obviously they were content with it and there was nothing more to do about it. What's the specific?
Brian, sorry, can I just stop you for 1 second? Guys,
Sure.
I do not have the mute control here because Brian is host, but there is someone who is speaking named administrator's phone. And Brian, we're either going to have to boot this person or you're going to have to mute them or change me back. I need people to mute so that, no. Brian, do you see the administrator? Can you make me host for 1 second? I'm just going to take control.
I can do the stop share, I guess. For
No. Keep on sharing.
Okay,
sharing.
that's all I can see on my screen.
Hold on 1 second. I'm going to replay.
Okay, unless there's.
I got it. Okay.
Okay.
I just muted that person. That's fine. Go ahead, keep on going, Brian. I have
Okay,
to go now.
I wish I was more experienced with, what we're gonna have to do is, if I'm ever doing one of these things again, we're gonna have to get somebody that's very techie and they sit by my
It's fine.
side.
I have control now, Brian. I'm good.
Okay,
I can mute them. Go ahead.
Perfect. Okay. So here's the actual wording that we're going to have in terms of that survivorship provision. The parties agree that the representations and warranties stated herein shall survive and not merge on completion of this transaction. But here's the extra words, but apply only to the state of the property at completion of this transaction. So that's the standard wording that you'll find in the AREA material. And what that actually accomplished is that just got us past the doctrine of merger, which was the first step. We got past that long-standing doctrine that we've thrown out the original contract. However, what time period did we agree to? Well, just the closing date. Well, is that what you want? Probably not. Don't you want like 2 days later at least, so that you move in and you can test some of the equipment? Wouldn't you actually like 10 days later? It gives you a little bit of an opportunity to move in and assess things. And of course, it may very well be that from a seller's perspective, it's no, I don't want you running all the equipment like a crazy person and then complaining to me that it's broken. It worked fine for my purposes, but may not work fine for your purposes after. So that's something that's in negotiation. A case in the small claims court looked at a period of 13 days, and the judge concluded that he wasn't in a position to be certain as to whether something was broken on the closing date or whether it broke afterwards. And that was the buyer hadn't identified that problem early, but had identified it only 13 days afterwards. That was too late. So the question then is, well, I suppose you have most of the next 24 hours to test out equipment. But any additional time that you have is really borrowed time. And by the time you're 2 weeks out, you're probably going to be in very rough place to try and establish that it was broken at the time of closing. So if you need more time, just specify it. Say it in the agreement of purchase and sale. Say, I need 30 days following completion, and put that in. And then you've got the 30 days. Or perhaps you need until a specific point in time, 31st of May, 2021. Why would you need that? If you're putting in a representation about a swimming pool, you're not going to be able to open it up probably any sooner than necessarily the May long weekend or whatever. And it's at that point in time when you'll get your first opportunity to see whether that works. We'll also come up and have a look at the swimming pool clause a little later on. Now, if you want to get past the as is, so remember, we have an agreement of purchase and sale, and it's as is. So how do we get past that? Actually, if we put it in this clause, that actually accomplishes it. It's in the AREA material, and it says the seller represents and warrants that the chattels and fixtures, as included in this agreement of purchase and sale, will be in good working order and free from all liens and encumbrances on completion. Parties agree, again, survive, not merge. Now, that gets us past as is. So we didn't buy as is. We bought good working order on closing. So that's helpful. And although it's a very innocuous clause and people see it, very often sellers are not picking up, hey, you really changed things up quite considerably by adding this small little phrase that's in there. I didn't realize that that would be the case. And so you've switched over, and that's very, very helpful. So on a buy side, you really like to have it. On the sell side, you have agreed to provide something other than as is condition. Certainly not something that you'd find one of the mortgagees doing in power of sale. Now, what if you see it and it's in on your counter sign back? Here's the wording. Now, I've pulled this wording from the RIA forms. And the reason why I've done that is that's where I'd like you to find your clauses as a source. All right, go to RIA, look through there's a booklet that's available in terms of clauses. Download that, have that available to you, and use those. What you'll find is that sometimes there's other clauses in circulation. The ones that RIA have been updated and revised to make sure that they're current. So here's the one that's from RIA. The buyer acknowledges that there is no express or implied warranty by the seller on the chattels and fixtures included in the agreement of purchase and sale. So that's on the sign back. Or what you could do is just cross out that clause that was put in by the buyer. So when we're looking at warranties, there's no walkaway. Statements concerning matters which are to be fulfilled, addressed, completed in the contract. The transaction will in fact be completed and closed. If it's not satisfactory, then there is a remedy, and that remedy is an abatement in the purchase price. All too often I hear real estate agents commenting and stating the fact that there's a warranty, and if it's not fulfilled or it can't be accomplished in some way, that the buyer can refuse to complete the transaction. No, that's not it. You have bargained for a warranty, and that's what you get. If it's in a warranty, what you've agreed is I'll take an abatement in the purchase price. So it's not necessarily an unresolved issue, but it's not a walk away from the deal. That is not the solution. Now, here's the mortgage financing clause. And really, there's two clauses that I want to look at today. One is the mortgage financing clause. It's the one that we'd love to have in on the buy side, and also the home inspection. Love to have that in on the buy side. It may be that you can't do any of this right at the moment, but this is the standard mortgage clause from RIA. So this is what we're looking at. Now, it's important, I guess, to be aware of the fact that in the RIA booklet, they have updated this to state a couple of things. And so since people don't download the notes, let's take a minute and just have a look at what RIA is saying about it. That's in respect to the use of this particular clause. Sellers should be aware that this condition does not contain any specific terms of the proposed financing buyers wish to arrange, and thus provides buyers with more latitude in declining financing. I wouldn't necessarily say that that's entirely true. The asterisk is mine, and we'll look at some of the court decisions that deal with this. And of course, I don't actually think that satisfactory financing gives you a better out than putting in, for example, 2 3/4% financing. And then you go and you can't arrange 2 3/4. You can get 3 1/4, but you can't get 2 3/4. So that's a significant difference. Now, the other thing that they've commented, buyers using this clause should be advised that they have an obligation to make a good faith effort to arrange the necessary financing, and should not use this clause inappropriately as a means to cancel the contract. Absolutely. And that's very, very important to be aware of that fact. So the mortgage clause in detail, what I'd like you to do is I'd like you to download it. I'd like you to pull it apart. I'd like you to have it in Microsoft Word and pull it apart paragraph to paragraph and read it so that you can see exactly what it says. And so we'll look at it in a little more detail in a moment. And so what we have here is, this is the whole clause. This offer is conditional upon the buyer arranging, and that tells us who. At the buyer's own expense, that tells us who pays. A new charge or mortgage, that tells us what we're doing. And then it says satisfactory to the buyer. This is going to be an evaluation. In the buyer's sole and absolute discretion, that's going to be the test. Unless the buyer gives notice in writing, so we do have a notice, delivered to the seller personally or in accordance with any other provisions for the delivery of notice in this agreement of purchase and sale or any schedule thereto. That's the delivery. We've got to undertake that if we're going to be dealing with this. Not later than, that's the time period, that this condition is fulfilled. That is satisfaction with this. This offer shall be null and void, and that's the result. And the deposit shall be returned to the buyer. That's the consequence, in full without deduction. And that's a calculation of the fact that they're getting the full amount. Excuse me. This condition is included for the benefit of the buyer. That's whose benefit it's for, and may be waived. A waiver is permitted at the buyer's sole option. That's who decides, by notice in writing to the seller as aforesaid. That's the notice within the time period stated herein, and that's the time period. So that's all outlined as to what we're looking for in terms of a particular agreement. Now, just look back where it says specifically the words, and may be waived. Now, when you say may be waived, that means exactly what it says. It may be waived. A waiver is permitted, and it's set out right in the agreement of purchase and sale. That's in the clause. So although people like to discuss, we have a notice of fulfillment, and we have a notice of satisfaction, or we have et cetera, et cetera. You don't have to use them. Go ahead and use the waiver. It says so right in the provision, and it doesn't have any greater meaning, less meaning, anything else than here's an opportunity. Use it. It's available to you. Now, what I wanted to point out about this particular clause is it's a great example of a very well-drafted clause. People have spent a lot of time coming up with this particular clause. It's excellent. It's clearly expressed. There's no ambiguity in it. And what I'd like you to do is, if you have to come up with another clause that you're drafting at some point in time in the future, look at that clause and use that as the checklist. These are the provisions that perhaps you want to consider going forward. So you need to have somebody do something. Now you know who's doing it. Seller, buyer, what's the time periods, what's the consequence, and what's going to happen in the transaction, and then how do we firm things up going forward. So this would be a great clause to use as a checklist if you're drafting something else. Now, in the material, we were looking at something, and that is vendor take-back mortgage. These were popular in the 60s and 70s when it was difficult to arrange financing, with all kinds of financial institutions entering the business in the 70s and 80s. It fell by the wayside somewhat. But you know what? Right now, it may be very attractive, and it could actually work. So here's what it looks like. It's a vendor take-back mortgage. You have a situation where you want to outbid somebody. You don't have any more money. You can't get any more money from your bank. You're done. But you want to outbid the next guy by $10,000. So what do? Get the vendor to take back a mortgage for $10,000. You can't pay them now, but you can pay them later. So all of a sudden, in a bidding war, you've got a little bit of latitude. You're in a situation where you can use this clause, and it's helpful. Now, what if you're on the vendor side? Well, if you're on the vendor side, we have one little problem, and that is the risk of an Oklahoma deal. And what that is the buyer over financing. So you sell them the property for $500,000. That's what it's worth. Then you agree to take back a second mortgage for $50,000. And you say, okay, that's fine. And so you're going to assume that they've got some money in the game, and that there's a mortgage much lower than yours, maybe 425, maybe 400, and then your 50,000 comes in. No, no. What they might be planning to do is buy your property for 500,000, put on a mortgage for 600,000, and then your $50,000 mortgage comes in after that. Well, it's unsecured. That's just a promissory note. It's nothing. So in order to do that, what you want is a cap on what is the size of the first mortgage. I'm going to give you 50, but you know what? I'll only give you 50 if you don't have a first that's in excess of 400 or 425. 425 be probably the top end amount that you would agree to. So that's what you need then if you're on the sell side and you're looking at that. And the vendor take-back mortgage can be very, very helpful at this point in time if it's utilized when in bidding wars. Now, let's forget what it says literally. That's the clause. Let's go with the legal interpretation. What do the courts say? Has the Supreme Court of Canada ever looked at this? And if so, what do they say about it? So a very important change in contract law took place in November of 2014. The Supreme Court of Canada considered a case, Basson and Renew, and basically changed the law. What they said was good faith contractual performance is required in all contracts going forward. In other words, you can't weasel out of them. Now that applies to completing the transaction, but it also includes, when we go back, any condition clauses that you may have inserted at the outset. So good faith applies to all contract clauses. The previous test used to be somewhat objective. So we would look at a situation and we would say, Brian, it's your offer. You couldn't get any financing. Is that correct? Yes, I can't get any financing. But now what we're going to do is say, gee, you know, that's not really quite the right way to do it. What we're going to say is, was it reasonable for Brian to have declined the mortgage opportunities and the financing that was available to him? And that's going to be with respect to satisfactory financing. So it's not just going to be me being the person who says it, and my evidence is individually is sufficient and complete. We're going to look at what would a reasonable person do in my particular position. So that's not quite as good from my perspective, because I used to get the opportunity to call all the shots. So that's really where we've moved from the subjective test, that was me, to an objective test, being a reasonable person. And so you can get around it, certainly if you have an option to purchase. So yes, there's a way of getting around this whole aspect, but make sure that you're exercising simply an option to purchase, and that's clear in the agreement. Oh, that's not going to go well in a bidding war. Multiple bids, and you're putting in 2 or 3 days while you fool around, decide whether you want to buy the property? I don't think so. That's not going to float. So you're going to have to come up with something a whole lot better. Now, there's a couple of cases recently, and so it's helpful to kind of have a look at this. There's a couple of cases recently which have come out dealing with Basson and Renew. And what you appreciate is, remember, of course, it takes 7 years to go through the Supreme Court of Canada. And we had a couple of cases, and they read Basson and Renew and said, oh, geez, we're going to, the contract law has changed. And by the time they get to the Supreme Court of Canada, one is 2 weeks before Christmas, Callow and Zollinger. And the conclusion there was there's a duty to perform contracts honestly. And that's commonly now referred to as the duty of honest contractual performance. It applies to omissions subsequent to a contract, and the obligation to advise of failure to renew a contract upon expiry when that fact is known, while the other party acts to its detriment. In this particular situation, we had a property manager, and the property manager was looking after a series of condominiums. Now, there were two contracts, the summer contract and the winter contract. And certainly the property manager knew that it didn't do a good job last year on the winter contract. Not exactly the best, some complaints. So what it did during the summer contract is it overperformed. I mean, you could see the daisies coming up everywhere. It was beautiful, manicured. They overworked. They did an awful lot more than what they might be expected. And it cost them a lot of money in order to do that, because there's quite a number of condominiums that were part of this contract. My guess is around 20. And so now the situation was, the board of directors had already made a decision. All right, this is in the summer. This is spring, summer. They already knew this. What they knew was, we're not going to renew that winter contract under any circumstances. And while it wasn't up to the date for renewal, they knew it, and they failed to advise the contractor. And the contractor was continually overworking on the summer contract. That cost the contractor money. Second thing is, if the contractor knew early in the deal, hey, listen, you're done. We've got somebody, we're going to go with somebody else. You are not even close to getting this under those circumstances, then what we're going to do is move somewhere. Failure to provide that information resulted in the contractor not having the opportunity to get other work. What they could have done is stopped watering the flowers in the summer beyond what was necessary, and come up with a program where they got other contracts for the winter time. The Supreme Court of Canada, basically, there's a couple of things. This is really pushing the envelope here, because what it requires is you really to wonder, all right? It was an omission. We didn't say that you were going to be renewed. We didn't say you were not going to be renewed. We didn't say anything. And it's sort of like, oh, geez, that's really pushing the envelope. Okay, at least prior to this, we have specific acts. Here, it's going to apply to omissions. It's what I failed to say. Now, it's important to be aware of when we're looking at these types of situations, the contract is in place. All right, we already have a contract. This is not negotiations. This is, we have a contract which is in performance mode at the period of time. And this is a failure to sort of recognize. Now, one of the criticisms of this particular case, not that anybody can do about it now, is the fact that, gosh, you've got to be a little bit of a mind reader as to what the other person would be thinking in the contract. Are you giving them the wrong impression? So certainly that's brand new, 2 weeks before Christmas, this past Christmas. So the next decision that came out is WASTEC, and it was the 5th of February, 2021. And it's really the triumvirate in terms of those three cases. This is it, and it was dealing with the exercise of discretion. The WASTEC collected refuse. Greater Vancouver had a system where it allocated garbage to various sites, and it had the opportunity to allocate the garbage to various disposal sites. Now, what happened was, the consequence of that was that WASTEC had to drive a little further, and it took them a little longer, and it cost them a little more money. But that was part of the deal in the first place. And the Supreme Court of Canada said, well, you're okay to go ahead with that. You're acting in your own best interest. That's okay. You don't have to just submit completely to what would be in the best interest of the other party. You can act in your own best interest. That's fine. That was reasonable in terms of the exercise of your discretion. So when we're looking at this, we're looking at the issue of absolute and unfettered discretion. Party exercise powers of discretion reasonably, number one, is measured by reference to the purpose of the contract and the purpose for which the party was granted that discretionary power that we're talking about. So the proper exercise really is an exercise of a right or power that is consistent with the purpose for which it was granted, and that that was reasonable under the circumstances. If that's the case, that's the proper exercise. The unreasonable exercise would be to exercise that right or power in something that is unconnected with the purpose for which or that would be unreasonable or arbitrary, and therefore in breach of the obligation of good faith. So if it's unconnected to the purpose, then that is unreasonable. So let's say we look at a financing condition, same condition that we had there, and a buyer comes along and wishes to terminate. So now we have, what are the reasons? Well, they suffered buyer's remorse. Oh, gee, I'm not quite sure that that's going to be good enough. Next thing, they never applied for financing. Well, a reasonable person in a buyer's position who wanted to close the deal, they'd apply for it. That's crazy. They should be applying for it. And then they fail to seek. If you were serious about it and you were turned down by one bank, you'd go to another bank. You'd go to a mortgage broker. In fact, you might even go back to the vendor under the circumstances and say, would you finance a little part of the purchase price for me? The other reason is you can't terminate if you find something better. So all of a sudden you buy on a Thursday and you've got until Tuesday to firm up your financing. And then all of a sudden a good property pops up on the weekend and you decide, oh, I'm going to buy that instead. No, that's not a good reason. All right. You've already got a deal. So all those reasons would be insufficient under the circumstances. Now, what would be some good reasons? Well, a buyer, by just coincidence, lost their employment. All right. So whatever that may happen to be. They were, in fact, turned down for financing. They looked at a secondary financing and they were turned down for that as well. Or that financing was available, but only at excessive interest rates. And you say, you know what? Those are good reasons. That actually makes sense. And it's the purpose for which that clause was put in the agreement. It was not put in to give you an out that if you found a better property around the corner after you struck the deal, to give you a weasel clause. No, not the purpose at all. So here's the home inspection condition. Again, this is the one that's drawn from AREA material. Gives you an opportunity to conduct a home inspection. And again, we'll go through that in a little bit of detail. This offers conditional upon the inspection of the subject property by a home inspector at the buyer's own expense and the obtaining of a report satisfactory to the buyer in the buyer's sole and absolute discretion. So again, we're back to this absolute discretion. Unless the buyer gives notice in writing delivered to the seller personally or in accordance with any other provisions for the delivery of notice in the agreement of purchase and sale or schedule thereto, not later than the offer will be null and void, deposit goes back to the buyer. And that's it. And so with respect to the inspection termination, what we have to have is something that's fair and reasonable. The purpose is to protect the buyer's rights. And what we have is matters that are justifiable in the context of this particular transaction. So $5,000 worth of repairs, it may be a lot of money if it came to a $250,000 condominium apartment. But if you were buying an industrial building worth $20 million, $5,000 of repairs would be absolutely nothing. You'd say, that's wonderful. What good news. So inappropriate exercise of discretion. This is what I'm saying, that the home inspection report was not good enough and didn't meet my expectations. Why? Well, I've suffered buyer's remorse. Oh, I don't think so. That's got nothing to do with that particular clause. I'd never applied for financing. I didn't get any alternate financing. I found a better property. And it identified a few handyman repairs. Okay, these aren't good enough reasons. You do need good enough reasons that fit in with the circumstances of the contract and that particular deal to be able to get out. So what I'm going to give you now is a slightly different clause. This is a clause which can be helpful. All right, so you've got bidding wars. You want to be successful. You think you're going to have a client who's going to give you the highest bid, but my gosh, you know what? They honestly can't just take the risk. We've got an older building. We're not sure what the situation is, and we just have to have an inspection clause. And there's no inspection available, and we couldn't figure that out. Okay. So here's the clause. This offer is conditional upon the buyer at the buyer's own expense having the building inspected by a professional insured home inspection firm to determine that the building is in sound structural and mechanical condition and that the electrical system is safe and adequate, and that in the written opinion of the home inspection firm, all deficiencies can be remedied at a cost not greater than $25,000. I've got 12. I'll change that. $25,000. So what that gives is you're in there and you said, I will pay for the first $25,000 worth of repairs. If there were repairs, that's fine. But as it sits here, the first $25,000 will be mine. Now, if you're on the sell side, you say, well, you know what? This is a good house. There's nothing wrong. There's certainly not $25,000 worth of repairs. Here's the threshold that they're saying that they'll eat the first $25,000. And if that's the case, then the home inspection should be fine. We're pretty happy with that. They've come in with a higher price than anybody else. They've beaten out everybody. Let's go along and take this offer. Now, this is the rest of the clause that you would see with that. So this is the tail end. I don't want you to think that that was the full clause, but this is the meat of it in terms of giving you some assistance if there's a bidding war. Now, another clause which is important to be aware of is swimming pools. So we want to have a warranty. It's the winter time. The buyers agree that the swimming pool shall be open not later than the 31st of May, 2021 by a professional pool maintenance company selected by the seller. So the seller has already got somebody that they have used for the last 10 years. We're going to do it at the buyer's expense because we've already closed the deal. They bought and closed in March. So, but we don't know whether the swimming pool works. So we're going to wait and see about that. The seller represents, warrants, and agrees, a couple of things, that the swimming pool, to the best of the seller's knowledge and belief, its equipment and fencing of the said pool comply with the applicable bylaws, regulations, and legislation. Now, that's simply in terms of compliance. That the swimming pool and equipment are now and on a date 60 days following the completion date shall be in good working order. So you got to make sure that that date matches up with when you're going to open the pool, etc. To pay for the cost of the repairs required, not covered by insurance, in excess of $500, which are required to place the swimming pool in good working order. So good working order is your deal. What you're going to find is, okay, if there's a claim, a potential claim here, if it's covered by insurance, then the seller doesn't pay. Second part of this is the first $500 is going to be the buyer's responsibility. You know what? That's just fooling around. Every time you start up a pool, beginning of the year, you know what? It should be the buyer who expects to pay something in the range of $500. Otherwise, we don't want to really get involved with it. And then, of course, that the transaction shall survive completion. So There's no weasel clause in the agreement of purchase and sale. Just because there's a condition in the APS doesn't mean that the buyer can weasel out. And the consequence of that is twofold. One, you can't disappear. But just because you can't disappear doesn't mean, what that means as well is the deposit is at risk, even on a conditional offer. And secondly, there's potential liability for further damages, just as if the deal happened to be just as if it was firmed up and you were going to proceed to closing. So what I wanted to do is just briefly mention, I do have a couple of courses that are available if people are interested in sort of pursuing this type of thing further on. You can find them at my website, which is ontariorealestatesource.com. In my prior website, I lost about 6,600 real estate articles. Eventually, they'll all be reposted here, but I haven't had time to do that. So eventually, you'll find them there. Also, there's a schedule, because I've customized this particular website. There's a schedule for courses. So anybody can just pop in there and see when the courses are. The program that I have is a consolidation of a group of courses that I had, 10 in number, and they're delivered over now Zoom format, 6 half days. And so Monday, Tuesday, Wednesday, and then the following week, Monday, Tuesday, Wednesday, and then we're finished. There's a quick exam. The exam is, what are the fiduciary duties of an agent? So you should, after you've taken the class, you should be in a position that you can fill that out very, very quickly. And then you have the use of the designation, which is AEA. So that's fine. That's the course. If anyone wants to join in, I have 2 programs that are starting up. One is March 29th, and that'll be the full session, and that's open, not filled yet. Same thing with mid-April. It'll start April 12th. So present session is fully booked, and we have a number of people that are have started to enroll in those next 2 courses. Whether there's going to be May, June, July, et cetera, I would be inclined generally to wean it off so that I wouldn't have anything in May. I wouldn't expect that, or over the summer. Just like everybody else, I've been sitting in the house, not able to do anything other than walk the dog for the last year. And so if there's any opportunity after June to travel around and that's permitted, I would do so. So hopefully that's available to all of us. So let me just stop share. And I think we're just on time. Probably have opportunity for a couple of questions if anybody had them.
Terrific. Brian, can you see the chat function?
No, I'm not
You
seeing.
push chat. Okay, so Dennis asked, thank you, Brian. Question, can you give any idea how to squeeze a conditional on financing into an offer at a time of a bidding war? Something similar like your example on inspection clause with 25,000 K.
I would say with a letter. Sometimes, so it won a bidding war with a lawyer who only does work in the federal court system on immigration and people being thrown out of the country. So for working for the federal government, he was in a situation where he couldn't get financing, and it wasn't going to be available to him from any bank. They didn't want him to have any financing ever showing on any property that he would purchase, because they thought, you know what, somebody could exercise some leverage over him. They also were trying to ensure that his name would never be publicized in any proceedings. So in situations with respect to deportations, that was always excluded. You wouldn't see who was representing the federal government, either federal court of appeal, Supreme Court of Canada, his name is there. Why? Because all the people are completely notorious. So to a large extent, this was a secret. Now I realized, he doesn't have the financing in place, but he can definitely get the financing. All we're going to need is a cooperative vendor to realize that. So we put that story in a letter, and that was delivered, and that we needed these number of days for the government to approve and arrange the financing for it. And the vendors went along with it and accepted his bid. Now, if his bid was less than everybody else's, of course, he wasn't going to win. But when they saw that, they did take it with the condition in it. So I would say if you have a good story, or you can say, I'm well financed, or I need to go back, or I'm short. But the other little wrinkle to this would be, if I don't get my financing, I'll give you a vendor take back on this. So let me apply for the financing that by way of a first mortgage, and I'll give you a second mortgage at slightly higher rates, but I want to be able to pay it off if I get the financing. In that case, the vendor is looking at, I get the extra money, and I either get my extra money now on closing if he can get the financing, or alternatively, we bump it out. But otherwise, I think, you're at risk. And it may simply be a question of sitting down with your buyers in the spring of 2021 and saying, you know what, we can't honestly participate in all of the bidding wars that are here, or we're going to come in 5 or 6 out and we'll just see. And most of the time, those people end up buying later in the market, and they might get a better price and a better property. But of course, that's difficult to say now when the market is so hot.
Right, two more questions here. JP Lutz has had his hand up in Zoom language. So JP, go ahead, and then I'll read Hillary's question that she put in the chat, and then we'll wrap it up for the day.
Okay, great. Thanks. Can you hear me okay?
No
Yeah, I
problem.
can hear you.
Okay, perfect. So now in a more balanced market, first of all, I just want to say I've taken your course and I absolutely love it. And I look forward to having the option of sitting in again in my allotted 1 year time. So thanks again for that, Brian. And okay, so my question is real quick. So you know how though it's worded, if notice is not given in writing for the home inspection clause, right? Up to this date, and this is for the sole protection of the buyer or sole discretion of the buyer. There's, like you were saying, how, let's say in a balanced market where a home inspection comes back and there's maybe $2,000-3,000 worth of work, and now they're trying to negotiate back and forth, right? So if they don't deliver notice within that time frame, and it states that the agreement is now null and void, is that not an out still for the?
Yes, that's an out for the buyer. Buyer
Right.
identified some things now, and then the question for the seller would be, do you think that there's some sort of an end run that's being handled here? And maybe there is, but if there isn't, then the person can reasonably terminate for that reason, provided it all fits. So what we are looking at here today in the presentation is really the extremes. So $5,000, for example, is that big or not big? With respect to an industrial warehouse worth $20 million, I say it's nothing, zero. Buyers should be rejoicing. If it came to $5,000 of repairs in a condominium and it was knob and tube, a person might say, oh my gosh, I didn't know there was knob and tube in here. And I'm more worried about not the knob and tube in my own unit, with a little bit of flooding because I can mop that up. But what I'm worried about is the knob and tube in the unit on top of me, because it's coming through the ceiling, and the one on top of that, et cetera, et cetera. So that's an indicator.
How about if it was more of like a gray area? Like if it was like, let's say aluminum wiring totaling about maybe $5,000 to $6,000, and the home is maybe 800,000. Like how do you translate
No
that?
idea. No idea. Each
Okay.
case is on its own, and it would just be general impressions. So on the one hand, I want you to be aware of the fact that it's not a complete walk away, no matter what, but by the same, so you've got to exercise that decision in good faith. And so probably using the term weasel, I use that specifically because it seems to have more meaning. People know, yeah, you can't weasel out of it. If you're trying to weasel out of it, yes, you can't do that. But where is it in terms of a range? There's a whole spectrum, and I'm not quite sure.
Okay, guys,
Right. And then I guess the best part would be, I guess the best thing to do also to would be prudent was to make sure that your seller already has a lawyer in place, that way you can contact them prior to and while all this is going on, right?
Absolutely.
Perfect. Thank you.
Guys, I know we're 2 minutes past our time, and we usually don't go over, but we had a bit of technical issues at the beginning. We're going to have one last question from Hillary, and then we're going to call it. Any of you who would like to communicate with Brian, he's always online, and more importantly, his courses are things you should attend, and you'll have plenty of time to ask him during those courses. But Hillary asks, hi, Brian, thanks so much for this. If you're representing the seller and you believe the buyer is not trying to fulfill conditions in good faith, how do you approach that? I feel like most sellers wouldn't want to pursue legal action.
I guess just briefly, if you have a strong lawyer on your own side, then they can evaluate whether or not it's reasonable, what the costs are going to be, and what the time is going to be. So in some cases, the answer would be yes, press on with a claim. In other cases, the answer would be, you know what, this is just too much aggravation, and why not take the money we were going to spend on a litigation lawyer and enjoy a nice trip to Florida. So
very good. So guys, we broke 100 people today. We're going to have a lot more that kind of watch this on the reverb as it is. Brian, I can't thank you enough. Guys, I mean this genuinely, not just because Brian has spent his hour with us, but rather because I think it's like almost a mandatory requirement of good professionals to continually educate themselves during the course of their career. Brian provides that opportunity in a unique and wonderful way. Many people on our forum have taken his classes. Many of the answers that actually are derived on our forum are because they remember things that Brian has said. This is not a waste of your time, and it's not an advertisement we're giving to Brian merely because he was good enough to attend today. It's a genuine bona fide plea to you to actually develop out your skill sets by attending courses like his, which are really best in industry and best in class. So Brian, we thank you sincerely for coming today. Again, I apologize for the technical issues, though one person was good enough to actually explain to me how we can make sure this doesn't happen again. I'll make sure that doesn't happen again. This will be up on our website within the next couple of hours. Brian, I'll send you a copy as well. And thank you all, over 100 of you who've attended today, and the many more who will watch in the next 24 hours. Thank you sincerely.
Good. Thank you very much.